Hey guys, this is Courtney Sealey. I was assigned case studies, which is the Texas Cattlemen versus Howard Lyman and Oprah Winfrey. It's a really detailed case. I'm going to say as much as I can in the 10 minutes that I have, and then I would suggest that you go and read my paper because there's a lot more details in it. In 1996, Britain experienced a major mad cow disease breakout, and it was spreading like crazy because what the farmers were doing were grinding up diseased cows. They didn't know they were diseased, but they were grinding them up and then feeding that diseased meat to other cows, and it just spread rapidly. Even though there weren't any signs in America at that time, Oprah decided to do a show on the cause and effects of mad cow disease. She had several guests on. She had both sides, like pro-beef people, and then she had anti-beef people. And the most important guest for anti-beef was Howard Lyman, who compared it with AIDS. He said that the disease had the same effect as AIDS, basically. Oprah did have pro people on there, like I said, but she edited out a lot of their part, and what she left in just spun the review tremendously. So it made them look like the bad guy. But at the end of the show, Oprah said that she had just been stopped cold from eating another burger. Well, the 90s were a good time for Oprah, and after the episode aired, cattle stocks on Wall Street just crashed, and she basically caused widespread panic. And because of this, several cattle farmers went out of business, or they had to file for bankruptcy, and it was just a hard time. So, several cattle farmers from Texas actually sued Winfrey and Lyman for libel and defamation. They sued under the premise that they had violated the veggie libel law. What the veggie libel law is, you can read about it in my paper. There was a scare about, to make apples shine and to keep them fresh longer. There was a chemical that they were wiping on apples, and it had came back. Research had been done that said that it caused cancer. And people freaked out about it and stopped eating apples. It's basically the same case as this, but the government actually ended up banning the product. But it was showing that it caused cancer in lab mice, but they were also giving the mice 100 times the amount of the chemical. So, that's almost expected when you give anything that many chemicals. But after that happened, several states made these laws to deter people from defaming product. And there's several things that go into this law. Like the food has to be perishable. You have to be able to prove that you have losses and that the people you're suing caused that. But it actually kind of contradicts itself, and I'll explain that later in my presentation. During the pre-trial, of course, Oprah used her national popularity to get PR for the case. She moved the show to Amarillo, Texas, so she could spend as much time with her lawyers on the case. But that's the same town that the main people were suing her in. So it's kind of, I don't know. I feel like she was just trying to get the town on her side by doing that. They could say, well, Oprah came to our little small town. And I don't know. She used her show as a way to remind the public that she was being sued simply because of her opinion. She focused a lot of her episodes throughout the preparation of the trial actually on the subject, more than she probably should have. During the trial, the plaintiffs focused on proving their losses because of Winfrey and Lyman's statements. He actually called Winfrey and Lyman as witnesses and asked them their interpretation of the statements that were made. They also had several witnesses testify to what the exact amount lost was. However, several of their witnesses in that matter contradicted themselves. So they didn't really have a good case lined up, I guess. The defendants just focused on whether the statements made were just facts or opinions. They stated also that others have made the same statements and allegations that they had, and then they argued that they have the right to their own opinion. After the plaintiffs rested their case, the defendants asked the charges to be dismissed, and the judge actually agreed. She said that sufficient evidence to prove slander, libel, negligence, and statutory product defamation had not been made. And then she said that the witnesses that the plaintiffs has actually validated a good bit of the statements made by the defendants. And then, of course, the Cattlemen appealed it, and it went to the Texas Court of Appeals. And usually appellate courts don't like libel cases because it's such a slippery slope. Like, it's so hard to prove libel. As you know, if you've had law class yet, it's just almost impossible. But the appeal court said that Oprah didn't even refer to a certain person or a company. So even if the Cattlemen had one, the beef and industry involved too many people to allow individuals to recover damages. Like, you might get like $20 from the ruling if everyone was paid. They also said, they just reaffirmed that you had to, they also said that the disparagement had to be of and concerning the plaintiffs, and since she never said, well, those Texas beefmen, the case wasn't eligible. And then the burden of proof was not met. They had to prove beyond a reasonable doubt that Oprah is what caused the market to crash, and they cannot do that. And then the final thing that they said, which surprised me, was live cattle were not sufficiently perishable for the law to apply to this case. For the veggie libel law to work, it has to obtain to perishable food. And I thought meat was perishable, but apparently live cattle was not sufficiently perishable. So the law didn't even apply in this case, apparently. I think that the case was just ridiculous in the first place. I think the Cattlemen were just bitter, and they wanted to take out their frustrations on Oprah. This case could not meet the standards of something being considered libel. There are 8 sections of libel, as you see listed, and I don't even think that they could have made half of those. The statements made were opinion. They were not facts. They were just opinions. They could have used the almond test from the beginning to decide that this was opinion. The almond test is something used by courts to decide if something is opinion or facts. And there's 4 parts about it. The 4 sections are, what is the social context? Can it be proven as truth or false? What is the original meaning of the phrase, and how did the author mean it? And the final thing that really just makes me think the case was ridiculous was, I thought it was a SLAP suit. SLAP stands for Strategical Lawsuits Against Public Participation, and what that means is that big companies like Walmart will hear that somebody has been talking out against their company, and so they will sue the person as a way to basically ruin their lives by having them making them pay defense fees for lawyers and stuff until they agreed to stop talking out against the company. Big corporations have plenty of money that they can just waste in frivolous lawsuits. And I think the plaintiffs and the lawyers knew they could not prove libel, and they had little chance to win. I believe that this case was meant to shut up Oprah and Lyman when they had every right to make the statements they did. I'd like to know your opinion about it if you want to discuss it on the discussion board. Do you agree with the judgment? Why or why not? Do you think there could have been a better ruling or a better outcome for the case? And do you think their case was frivolous like I had said on the last slide?